Can a voluntary proposed administrator file a malpractice or nursing home litigation on behalf of the decedent? To find out, you have to read Brown versus Mount Sinai West, but it's 3 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where normally I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. But this is part of a special limited series I'm doing on cases relevant to the elder law and estate planning community. This is the case of Brown versus Mount Sinai West, published out of the Supreme Court, New York County, on April 9th of 2024. The citation for this case is 2024 New York Law Journal, Lexis 1091. The issue in this case is whether a voluntary proposed administrator can prosecute a medical malpractice or negligence or nursing home lawsuit on behalf of a decedent. To understand and appreciate the concepts involved in this case, it's helpful to know that under the Estates, Powers, and Trust Law, EPTL 5-4.1, it specifically, that specific section talks about who can prosecute a wrongful death case, neglect case, some injury involving a decedent. Who can prosecute that kind of a case? And under EPTL 5-4.1, it states the personal representative duly appointed in this state or any other jurisdiction or of a decedent who is survived by distributees may maintain an action to recover damages for a wrongful act, neglect, or default which caused the decedent's death against a person who would have been liable to the decedent by reason of such wrongful conduct if the death had not ensued. So the person who can pursue that action is a duly authorized, appointed representative appointed by the state. The other thing you have to know is that under SCAPA, under the Surrogates Court Procedure Act, 1301 sub 2, there is something called a voluntary administrator. A voluntary administrator is not appointed by the state. It's only eligible for small estates of $50,000 or less, so smaller estates. But a voluntary administrator is a person who qualifies and undertakes to settle an estate without the formality of court administration. Okay, that's a voluntary administrator. But the thing you have to know about that is under SCAPA 1306 sub 3, that which lists the powers of a voluntary administrator, sub 3 says, the very end of it says, the voluntary administrator shall have no power to enforce a claim for the wrongful death of or a claim for personal injuries to the decedent. So a voluntary administrator can do certain things, but it cannot prosecute a claim on behalf of the decedent. And the last thing you have to know is under CPLR, Civil Practice Law and Rules, 3211, that's a motion to dismiss. And there's a variety of different theories under a motion to dismiss, but sub 3 is the party asserting the cause of action has not legal capacity to sue. It's essentially saying there's no standing. The person that's suing doesn't have the right to sue. Okay, so what are the facts in this case? The facts are that the decedent here is a person named Kevin Brown. And Mr. Brown lived in the defendant's nursing home, Mount Sinai West nursing home. And he allegedly suffered malpractice in the nursing home and then thereafter died. After he died on January 13th of 2022. A year and 3 months later, by February of 2023, nobody had received, no letters of administration had been issued by the Surrogates Court. So nobody was a duly appointed representative to handle the estate matters of Mr. Brown. But on that day, April 28th of 2023, the plaintiff stepped forward and filed a malpractice and nursing home case as against Mount Sinai West. In the complaint, plaintiff identified herself and said, I have standing because I am the proposed administrator of Mr. Brown's estate. In response, Mount Sinai filed a motion to dismiss under CPLR 3211A3, saying, lack of capacity to prosecute this case. You have no standing. Who are you to assert this action? Is essentially what 3211 sub A3 is. That it doesn't address the merits. It just says you have no standing to bring this claim. And this is the case that's before the court, before Judge John Kelly. And the holding in this case is motion granted. Why? Because the only person who has standing to bring a lawsuit on behalf of the decedent is the personal representative who has received letters of administration, like we talked about, under the EPTL. And that's the only person that can bring a wrongful death claim, not the voluntary administrator or proposed administrator. Now, in this particular case, it turns out after the case was filed, the person filed several months later a voluntary administrator certificate, but that's untimely also. So here the problem is two problems. First, it's untimely. She filed the action in April. She didn't get any letters of voluntary administration until September, 5 months later. So when she filed the case, she had no connection to the case, technically. Being a proposed administrator is the equivalent of being nothing. And even if she was, a voluntary administrator doesn't have the authority to prosecute this case. That's what SCAPA says. So the case is dismissed without prejudice. It can be brought again, if appropriate, by the executor once letters of administration have been issued. And that's the case of Brown versus Mount Sinai West. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.